Good morning, and thank you for coming. I'm pleased to be joined today by the New York State Attorney General Eric Schneiderman. Barclays and Credit Suisse, two of the largest dark pool operators in the country, have agreed to pay more than $154 million combined to settle our parallel fraud actions, finding that they misled investors about how they operated their dark pools and a related ATS. While these are not the first significant actions the SEC has brought against dark pools, they represent the largest penalties ever against dark pool operators, and the significant sanctions in these cases should send a strong message to the industry. Alternative trading systems, or ATSs, and dark pools in particular have received a great deal of attention in recent years among investors. Unlike exchanges, which are highly regulated and need to promulgate SEC-approved rules regarding their operations, ATSs are subject to less regulation. ATSs make representations to customers about how they will treat orders, and those representations must be accurate. Otherwise, customers are misled, and the integrity of our markets is undermined. To date, the SEC has brought a series of cases involving dark pools and other ATSs, including our case in August against ITG for maintaining a secret trading desk that improperly used its dark pool subscribers' confidential order information, for which we recovered $20 million. With today's case, we have filed 6 ATS actions in less than 2 years, and today's penalties represent multiples of prior penalties in these cases. Today's settled cases involve a variety of problems with the operation of Barclays and Credit Suisse's large dark pools and another Credit Suisse ATS called Light Pool. Most significantly, both Barclays and Credit Suisse claim to have a system. Barclays called it liquidity profiling, and Credit Suisse called it alpha scoring, for identifying opportunistic or aggressive traders, such as high-frequency trading firms, and permitting customers to opt out of trading with them. But both firms misrepresented how these systems worked, and both firms exposed ATS subscribers to opportunistic or aggressive traders that they had promised to screen out. Now, I'll briefly summarize today's charges using these charts to help summarize some of the misstatements. The case against Barclays charges the firm for its misconduct in the operation of its dark pool known as LX, one of the largest dark pools in the United States. Barclays made misleading statements about the steps it was taking to protect subscribers from predatory traders who accessed the dark pool. Barclays touted its use of liquidity profiling, which it described as, quote, sophisticated surveillance framework that utilizes robust visualization tools that allow the Barclays ATS team to continuously police the trading activity in LX. Barclays also said that it ran surveillance reports every week to make sure there was no toxic flow in LX's book. These statements were false. Barclays did not continuously police LX for predatory trading through the use of visualization tools, nor did Barclays generally run surveillance reports on a weekly basis during the relevant period to ensure that there was no toxic flow in LX's books. Barclays also told subscribers that it rated all subscribers based on the aggressiveness of their trading, and that subscribers could elect not to trade with those who were rated as aggressive. However, Barclays did not tell its subscribers that it sometimes overrode the ratings by recategorizing some aggressive traders as non-aggressive. One subscriber that received this preferential treatment was Barclays' own market-making desk. Barclays also made misrepresentations about the data feeds that LX used at a time when dark pool's use of data feeds was a subject of intense public interest because of the opportunity that the use of the slower data feeds presented for latency arbitrage by high-frequency traders. Barclays misrepresented the type and number of market data feeds it used. For example, it said that it used faster direct feeds from exchanges, when in fact it used the SIP feed for the New York Stock Exchange. To settle these serious charges, Barclays has admitted the factual findings in the SEC's order, acknowledged that it violated the federal securities laws, engaged a third-party consultant to review its procedures for marketing its dark pool, safeguarding customer trading information, and other regulatory issues, and agreed to pay a penalty of $35 million, the largest SEC penalty in a dark pool case. Together with the New York Attorney General's case, Barclays will pay a total of $70 million in penalties. We also filed actions today against Credit Suisse, one involving its Crossfinder dark pool, which is among the very largest dark pools in the United States, and a second involving Light Pool, which was a different type of ATS known as an electronic communication network, or ECN. Unlike dark pools, which do not display their best bids and offers to the public, ECNs do display this information. Credit Suisse made several misrepresentations about how Crossfinder and Lightpool operated. Some of these misstatements concerned alpha scoring. Credit Suisse said that alpha scoring was applied to all subscribers in Crossfinder monthly and in an objective and transparent manner. This was false. In fact, alpha scoring included significant subjective elements, was not transparent, and did not categorize all subscribers on a monthly basis. Similarly, Credit Suisse said it would use alpha scoring to identify opportunistic subscribers and kick them out of Lightpool. And that's the second on that chart. This was a misrepresentation because alpha scoring was not used for the first year that Lightpool was in operation. Also, a subscriber whose trading was ranked as opportunistic could continue to have direct access to Lightpool if it had multiple system ID codes for access, and Credit Suisse allowed subscribers that directly traded in the Lightpool and were categorized as opportunistic to resume trading if they simply told Credit Suisse that they would improve their order flow. Credit Suisse also engaged in other violations, including in Crossfinder, violating an SEC rule known as the subpenny rule. This rule was designed to prevent orders from getting priority based upon economically insignificant differences in their prices. Credit Suisse violated this rule by accepting and executing more than 117 million illegal subpenny orders, resulting in significant profits. For all of these violations, Credit Suisse will pay the SEC a total of $54 million, which includes $30 million in penalties and approximately $24 million in disgorgement and prejudgment interest, the most disgorgement ever paid in an SEC dark pool case. Together with the New York Attorney General's case, Credit Suisse will pay a total of approximately $84 million. Before I conclude my remarks, let me just say two additional things. First, I would like to thank the Attorney General for his and his staff's hard work and their cooperation as we work together on these investigations. I am proud of the strong relationship we have built with his office. Second, before handing things off to the Attorney General, let me recognize the SEC staff who worked on these investigations. Several attorneys and specialists from our market abuse unit investigated these cases with other extremely dedicated and talented staff in multiple offices throughout the Division of Enforcement. They include Jason Burt, Charu Chandrasekhar, Jay Scoggins, Thomas Smith, Nancy Brown, Charles Riley, Dee O'Hare, Catherine Pishka, Jonathan Polish, Stephen Schlegelmelch, James Smith, Mandy Sternfels, Darren Berner, Matthew Wong, and John Marino. Robert Cohen and Joseph Sansone, the co-chiefs of the Market Abuse Unit, supervised the investigation with the help from Tim Warren of our Chicago office on one of the Credit Suisse investigations. I'll now turn it over to the New York State Attorney General.
Thank you. It's a pleasure to be here today with the Director of the SEC's Enforcement Division. Our offices have worked together on many matters, and the matters we're concluding today are a good example of the value of that collaboration. We have today brought some light to some of the darkest places in the market where it is clear to us that investors were being abused and misrepresentations that had a significant effect on trading were being made. Let me just mention the member of us from my team joining our colleagues from the SEC, Chad Johnson, the Chief of my Investor Protection Bureau, John Castiglione, Rebecca Riley, Jordan Sahlberg, Jonathan Zweig, and my Senior Advisor and Special Counsel, Nicholas Suplina. These are really first-of-their-kind agreements with two of the largest dark pool operators in the United States, imposing a total of more than $154 million in combined penalties and disgorgement. Penalties are large. They're the largest penalties imposed in dark pool cases. The $70 million penalty that Barclays will pay is the single largest penalty ever assessed for misconduct by a dark pool operator. And the reforms Barclays has agreed to, in some respects, are even more significant. So our office's involvement in this began in 2014. We already had a broad inquiry into issues related to high-frequency trading going on, and discovered that there was some pretty egregious conduct going on at Barclays. We had the advantage of having several insiders, former employees, come forward with some extraordinarily important facts, and we determined that there was a systematic pattern of fraud and deceit against the investing public. The significant thing about the Barclays case is that, unlike some other firms, they really fought us every step of the way, claimed they did nothing wrong, said they didn't break the securities laws, that our office had no jurisdiction. Well, in today's agreement, Barclays admits that the operation of its dark pool violated the securities laws, admits to an extensive set of facts detailing its wrongful conduct. And combined with our amended complaint, it really lays out for investors and the public to see some of the types of activities that firms are capable of when the lights go out in a dark pool. They clearly lured into their dark pool investors with promises that it would be run fairly and they would be shielded from predatory traders, which they rated, as noted, through their supposed liquidity profiling system. And the promises were simply false. In fact, Barclays gave high-frequency traders preferential treatment, and by doing so gave them a leg up on the majority of investors. We had to file a lawsuit against Barclays in June of 2014, and at that time it was operating the second largest dark pool in the United States. That is no longer true. We uncovered further evidence after bringing the lawsuit that Barclays had violated the securities law through a long pattern of misconduct. And we feel very, very good about the fact that our complaint really gave investors a very clear view of what was going on, and a lot of investors began, especially institutional investors who are important because they hold the savings and retirement of a lot of New Yorkers, started asking hard questions. To give you a sense of some of the things we had to contend with, the Barclays actually edited out of its marketing materials references to one of its most aggressive dark pool subscribers to create the impression their dark pool was safer than it actually was. They just took this subscriber out completely. They also covered up the fact in their marketing materials that their trading systems were structured to send a disproportionate share of orders into their own dark pool, deceiving investors, and when some of their employees wanted to disclose this to investors, they were punished. With this settlement agreement, Barclays has made admissions, including admissions of violation of the securities law, but they also are going to have to install and pay for a paid consultant, an independent monitor, in essence, who's going to conduct a thorough review of the relevant portions of Barclays' business, work with Barclays to reform areas in need of reform, and who will report back to my office and the SEC. And this independent monitor, if there's a disagreement about reform between Barclays and the monitors wins that fight pursuant to this agreement. We're also announcing our settlement with Credit Suisse, which for a long time has operated the largest dark pool in the United States. And the coordinated investigation by our office and the SEC found that Credit Suisse also made significant misrepresentations concerning both Crossfinder and Lightpool, and mishandled client order information, falsely claimed that it did not favor its own dark pool. The resolution of that case involves a $60 million penalty and is noted by the Director of Enforcement, disgorgement for violating SEC rules as well. The penalties in this case, the $70 and $60 million penalties, will be split evenly between the State of New York and the SEC, resolving our investigations, and in the case of Barclays, our lawsuit against them. And I'm very proud of the fact that our office, since 2012, has been doing work in this area, cracking down on early leaks of market-moving data, on consumer and analyst sentiment, worked to and obtained agreements to end the distribution of corporate earning releases directly to high-frequency traders before they get to the investing public. There is more work to do to bring sunlight to these markets, but today's settlements are the most important steps so far, the most serious punitive measures and the most aggressive settlements so far in this entire area. We look forward to working with our colleagues at the SEC in further collaboration to keep bringing light to dark parts of the market and to protecting investors, and particularly on representing the people of the state of New York. We're concerned about the investment of retirement savings and pension funds, and the institutional investors that manage those were very much the targets of the misconduct in both Barclays and Credit Suisse dark pools. So I thank my team for their outstanding work, and I particularly want to note that The employees who came forward in the Barclays case really played a very important role, and I thank them for their courage. Today's announcements should go a long way towards bolstering public confidence. We don't view this as an attack on the industry. We view this as something to ensure that the public can have confidence in the markets and have confidence in their trading venues. So New Yorkers can rest assured we'll remain vigilant. I look forward to further collaboration with the SEC on this and other matters. Thank you.
We'll now take your questions, if there are any. Yes.
So for the uninitiated, dark pool, I'm sorry, dark pool sounds, Rich Lamb, WCBS, by the way. Dark pool sounds rather sinister to begin with. It doesn't sound legitimate. Is this a marketing device to make people think that they're somehow getting a better deal and nobody knows about it? I'm a little confused about it. I know I must look really uninformed.
Sure. So dark pools are not some nefarious operation, and if they're run correctly, which in this case we found that these were not, and that there were misrepresentations made, they are an important part of the market. If you look at our order, in the Barclays order in particular, footnotes 2 and 3 outline what an ATS is and then describe what a dark pool is versus what an ECN is. So dark pool does not send the best bid and ask to the consolidated data feed, while the ECNs do. That's the distinction between them. ATSs in general are alternative trading systems. They're different from exchanges. Exchanges are more highly regulated. They have to promulgate rules, and they're subject to certain additional requirements. ATSs are not, but they perform an important role in the market by putting, as I think the Attorney General said, institutional investors often together in a manner in which those institutional investors want to trade without the posting of their order information on a public consolidated data feed. And so they do perform important. The important thing about today's actions is that when telling investors how they are going to treat subscribers, they have to be honest, and they have to tell their subscribers exactly how they are going to actually treat them. The one other thing I'll say is that the SEC recently did promulgate proposed rules which would establish some additional requirements for ATSs. One of those rules is that the form ATS, which an ATS files, which sets forth a number of things, including how it operates, would become public under that rule, and that would provide additional transparency to the markets. Yes?
Hi, this is Mike from Bloomberg News. I just wanted to check to see if you describe whether this is just the beginning of an enforcement push or if there's other things you should be expecting down the line.
Well, the SEC, as I said, we brought with today's cases 6 actions in the last 2 years, and we certainly have other investigations ongoing. This is an area that we're very focused on, and I know the Attorney General is as well. And I won't comment on any future enforcement actions. We bring them when we find violations and when the evidence justifies it. But you can rest assured this is an area where both of our institutions are focused.
Are the individuals responsible for having
So today we did not announce actions against individuals. In every case that we bring, we assess whether to bring a case against individuals, and we do so when we find violations and when the evidence justifies it. Today we did not announce actions against individuals. I don't know if the Attorney General wants to.
No, but neither did we release any individuals from the possibility of an action. I do want to emphasize the fact that when we began our initial inquiries into high-frequency trading and dark pools in 2012, they were incredibly opaque and subject to abuse. And these enforcement proceedings, combined with the rules that the SEC has proposed, are really bringing more order to the Wild West and making it much harder for customers, investors to be abused. So the last few years have seen a dramatic change in the regulatory approach to these trading venues, which do perform a function if operated properly, but also created the opportunity for chicanery that was harder to detect. Today we take a big step towards making sure that doesn't happen in any dark pool. And again, at the end of the day, our goal is to restore investor confidence so that they can function as they're supposed to function and investors can rely on their representations as to how they're going to be treated.
Any more questions? Yes.
President Schneiderman mentioned that the people impacted by the behavior by Barclays, in particular, were like retirement funds and pensions. I was wondering if you could get a little bit more into who's really hurt by this type of behavior. What does this really mean for like the retail average investor? Why should they care that this actually is like that?
Well, it's an important point because some people think that this is really only high flyers would use dark pools, because you use a dark pool so that you can keep secret your effort to move large quantities of a security and not move the market. Not true at all. Institutional investors with the pension funds of New Yorkers, of unions, of public employees are major traders, and they do work in dark pools, and they should be able to trade in dark pools. And up until now, they were among the investors who were essentially being misled. And essentially, they were being misled. They were being lied to by both of these trading venues and thought it was safer to trade than it in fact was. High-frequency traders, particularly predatory high-frequency traders, who I guess Barclays called aggressive and Credit Suisse in more benign terminology called opportunistic, really can pose a threat to fair trading. And to the extent that there's representations made that institutional investors are safe from that sort of aggressive activity, those representations have to be honored. That's really the message today. But this is not just a matter of high-flying hedge funders. This does affect ordinary working men and women to a great degree.
Yes.
Sorry, John Craig Williams. You mentioned that you had come across the Barclays issues when you were looking at trading. You haven't seen anything on the trading side in general yet. Should we expect to see that anytime soon?
Well, you have seen some things. We have, fortunately, everyone we've essentially challenged about its use of high-frequency trading or making data available to traders. Reuters stopped. Everyone has agreed to cooperate with us and stop the conduct that was enabling the high-frequency traders. So Business Wire, MarketWatch, Thomson Reuters was releasing the information about the University of Michigan Consumer Confidence Survey 2 seconds early. They stopped that. BlackRock agreed to stop some of its activities with questionnaires that gave an early advantage. So we have, I have to say, to their credit, the players in the market that we've been dealing with mostly have, when we call it to their attention, have been cooperative. But we do have ongoing investigations, and we hope and we believe that these enforcement actions, the others taken by the SEC, the proposed rules, are going to help clean up this area and bring order and fairness to it. But we are proceeding on multiple fronts.
Yes.
For the two questions, first for the Secretary, what's the significance of having Barclays, acknowledge the Martin Act applies to this in this case? And secondly, are the whistleblowers eligible for
The significance of the admissions that Barclays made, if you put those together with our amended complaint, I think really lays out an excellent roadmap so that others can see what the rules of the road are and clarifies our office's enforcement powers in this area. I think it's a big step. We want to avoid, we would rather avoid unnecessary conflict. Our goal is not to litigate every issue. Our goal is to have clarity and enable the markets to work properly, and we think this is a big step towards that. As far as the whistleblowers, they're not eligible for anything from us. I don't know if they are from the SEC, but they came forward because they didn't like what was going on, and they wanted to call attention to some really egregious misconduct.
And I'll just add on the whistleblowers. We can't comment on whether the whistleblowers were involved here. In general, we obviously have a whistleblower program. Whistleblowers can recover between 10 and 30% of any recoveries that we get in a particular case. So that would apply generally, and there are rules that govern under which they can recover. Any other? One more? We'll take one more. Go ahead.
So I know I'm a total babe in the woods on this, but so can you give me sort of a real-world example of how one of these predatory guys are, what kind of an advantage would they get? What would he do with it? What happens? How can the average guy
Sure. Well, why don't I try, and we'll see if that works. So I'll just give you an example. If you look, for example, at our order with regard to Credit Suisse, just as an example, Credit Suisse represented that it applied objective elements to weed out particular investors, including high-frequency trading firms, when in fact it was using subjective factors, including a judgment that it would apply. And so what that meant is it told investors that investors could decide whether to trade with aggressive high-frequency traders or not. If I'm an investor, I could decide I don't want to trade with a high-frequency trader, and Credit Suisse told me that in fact I could do that. When in fact what Credit Suisse did was it allowed those high-frequency traders to trade not as aggressive, but to trade with the people who it said it would prevent from trading with them. So if I'm a trader and I didn't want to trade with high-frequency traders, given what Credit Suisse did here, as alleged, for example, in paragraph 45 of our order, it allowed those high-frequency traders to trade with me. So that's one example. And I would decide not to trade with the aggressive traders. I might decide that for various reasons, including that aggressive traders can employ certain strategies that allow them to benefit against me. For example, some sort of latency arbitrage or some other strategy that lets them benefit retail and other types of investors. I hope that helps you to understand it.
Let me try one. You're saying latency arbitrage doesn't help, Rich. Huh? As I say, one of the issues that was true in both these cases, but which was a particular concern of ours in Barclays and did involve the whistleblowers, is that both of these firms represented that they would place trades for an investor based on best execution. They'd get the best deal, whichever trading venue they had to go to, whether it was a stock exchange, their dark pool, or another dark pool. In fact, they were both heavily favoring and sending more trades to their own dark pools than were warranted by any standards for best execution. So when at Barclays, a big institutional investor asked for an analysis of what portion of the trades were going to Barclays' dark pool, and then their employees came up with an analysis that showed really devastating numbers, that the overwhelming majority were going to their dark pool, in spite of the fact there may be better execution available elsewhere. They told those employees to cover that up and not to disclose it to the investor, leading to big internal problems, one person getting fired, one resigning. So they didn't want investors to understand what was really going on. They were favoring their dark pools. They were letting aggressive traders trade when they said they weren't. So it was really a broad series of misrepresentations about what life was like in their dark pool. And after today's actions, we're confident that they're cleaning that up.
Great. Thank you.
These actions could cost millions, could cost billions. Is there any price tag? I mean, something you can put up?
We don't allege a particular price tag in our order, and we're limited to what we have in our order, but it could have a significant impact on customers.
Thank you.
Okay. Thank you very much.
Okay.